divorce, I saw a video that gave 3 questions that you should ask your lawyer. I figured I'd tackle them. First one that this lawyer identified was, what percentage of your practice is dedicated to divorce? Not a bad question. You'd like an attorney experienced in divorce, capable of identifying issues and handling the paperwork, and more importantly, presenting themselves in court. Can they do a direct examination? Can they do a cross-examination? Can they advance the argument that's most persuasive in this area of practice? So it's a good question to ask. I don't know that it's the most important question or even the first question that I would ask. If you go to an attorney that holds themselves out to be a divorce and family law attorney, well, we would hope that they have the credibility that they are in fact an attorney that can handle divorce and family. Maybe you want to give someone that's inexperienced a shot. Maybe you want to give someone that is crossing over into that field. Can you get along with the attorney? Can you communicate your desires and get a reasonable response from that attorney that they will in fact seek to obtain and secure what's important to you? Now, they're not experienced, you may say, I need, and not really be able to get what you want, and need, because the law just doesn't protect that item or issue that you identified as important. So there's some give and take in the field of matrimonial law, and you may want to rely on an experienced attorney to know what you can handle in a horse trade. Give up this for that. Another question this attorney identified was the cost. Cost is certainly important. Sure, hard to tell at the beginning, at the outset of your case. Now, if it's uncontested, we can give one fixed price for all of the work at one point and submit it to the court. But if it's contested, it's much more difficult to determine a fee or a fee structure. I like this rhyme. The more you agree, the lower the fee. The more you agree, the lower your fee. A fee and your fee. It makes sense, right? If we agree, you want to sell the house, and you both agree, no fight. You want to buy the other person out from that, out of their equity in the home, and they don't agree, well, maybe you have to file motion papers and go to the court and argue that particular issue. And is it even possible? And are we going to fight over an issue that the court might kick down the road? Say, we'll argue that it will determine or argue or hear evidence about that issue at trial, or what? Well, maybe don't fight about it. And if you can't buy the other person out, maybe you can at least agree to place the home up for sale now, saving money, saving time, and forging an agreement. Those are 2 out of the 3 questions identified. I'd like you to come back for question 3.